Welcome to the First District Court of Appeals. We have two cases set for argument today, and two cases are submitted. The first case set for argument is case number C-24-0565, and I have Mr. Cummings for the state of Ohio.
That's correct.
Okay, and then Mr. Gustafson for the Mr. Jenkins. Good morning. The second case set to be argued is case number C-24-0511, Nation Star Mortgage LLC versus Leslie R. Krunbrink et al. And for the appellant, I have Mr. Robert Krunbrink. Good morning. And for the appellee, I have John Murray. Good morning. So if the attorneys for the Jenkins case would step forward. Good morning. Would you like to reserve some time?
Yes, 5 minutes.
5?
Please,
Okay.
thank you.
I will keep your time.
Good morning, Your Honors.
Good morning.
Nice to see you. This is a straightforward case from the state's perspective. I think the trial court erred as a matter of law by simply applying the wrong standard of the law here in evaluating the case. The key to this case is the significance of the defendant's status as a parolee. He was paroled, and because he was paroled and because there's no constitutional right to release from prison before your term is expired, when the state grants somebody parole, they have the ability and the right to ask in exchange that the parolee will sign the rules of the probation and abide by them in exchange for being released early. And this is just like any other agreement in that sense, but it does have a very significant impact on the context of the case. When the parolee signs those rules, he acknowledges and concedes that he has to abide by these rules, and he understands that there's a diminished expectation of privacy. His Fourth Amendment rights, his constitutional rights to a degree are impinged, and that's contemplated and approved.
So what is the standard that we look at for searching somebody who's on parole?
Well, the standards in the statute, 2967.131C, and that reads that a field probation officer conducting a search, like was done here, must have reasonable grounds to believe that the person is not complying with the terms of his conditional release. The phrase reasonable grounds is not defined specifically, but it's important to realize it's not probable cause, it's not even reasonable suspicion.
Are you saying that the judge below applied a probable cause standard rather than this lesser standard?
I think, I'm not sure what standard the judge applied, but I think based upon the record, whatever standard he applied was not proper given the totality of circumstances of this case. The Griffin Court, the United States Supreme Court, has said, look, it's not a probable cause standard, it's not a reasonable suspicion standard, it's basically just some likelihood that there's going to be found a violation of a condition of probation. And that's a very low standard. In fact, our Ohio Supreme Court in State versus Benton actually said that you almost have to show ill will or ill motive on the part of a probation officer.
But even under that low standard, it can't be based on stale evidence, can it?
Yeah, in the sense that I think stale really has minimal relevance in a context like this. I think staleness is something that's usually evaluated in terms of probable cause to search an ordinary citizen. We don't have an ordinary citizen here. We have a parolee who's already forfeited his Fourth Amendment rights. He's acknowledged as much by signing those rules, and he has a diminished expectation of these types of principles because for him, he's agreed to an early release as long as he does certain things. So the standards that we're used to applying in a probable cause analysis or reasonable suspicion, they don't apply.
So staleness does
necessarily.
not apply? Are you saying that in a situation like this, staleness would never apply?
No, I think in some cases, I suppose, you would say that it would be unreasonable to rely upon 10-year-old tips or something. Yeah, I'm sure.
What about 5-year-old?
Possibly, yes. I
2-year-old?
guess it's in this, 2-year-old?
2-year-old tips?
Depends on the circumstances. Again,
Well,
we
how old
always
would-
must look at all the circumstances, and the parole officer can always look, and is supposed to look at the entire knowledge base that we have.
How old was the
about
tip
this.
here? How old was this tip in this case?
It was from December, it was like 5 months, 4 or 5 months.
Okay.
Does it make a difference here that the tip was about a gun rather than drugs or some other contraband that
Yes,
will be used quickly?
in my opinion, yes. I think the way these tips came about, they weren't anonymous tips. They were tips from this gentleman's girlfriend and his mother. And they said he carries a gun downtown in a bag, which is different than having like a personal use packet of drugs, which is probably going to be, used or consumed. Having a gun in a bag is more akin to having keys or a wallet. You carry it around. And I think that makes this particular tip much more actionable in the sense that the parole officer should have followed up on it. And if you look at the circumstances of this particular parolee, again, he's not an ordinary citizen. He has a reduced expectation of privacy. He signed the rules in exchange for his early release, which he was not entitled to early release. But he did get it because he agreed to abide by the rules, which he was notified means that he's subject to search. And in this case, the officer had a history of this defendant, that he knew he had 3 decades of guns and drug problems. He knew that he had violated probation repeatedly over the past 30 years. He violated it as recently as the December before this encounter, so just 4 or 5 months ago, this probationer had violated terms of his probation by failing to report.
Well, let me ask you a different question that I've been wondering about. There was, when it comes to this particular search, they were meeting in JFS, right?
I think they had arranged to do that.
Okay. And, but he happened to run into him outside beforehand.
Sounds like that, yes, yes.
Okay, would he have been stopped at a security check had he walked in?
Yeah, I would assume so. I don't know, but I would assume that was.
But there was no argument about that below
No,
or,
that
okay,
wasn't
in your
discussed.
brief.
Why didn't the parole officer move quicker on this tip? You have, as you described, someone who is a serial violator. They get a tip that this serial violator has a gun walking around downtown. Why the delay in moving on the tip?
Well, in the sense, he didn't delay in this sense. He got the tip. They tried to search his residence, and the girlfriend refused. So they weren't allowed to go into the residence. They did release him in January because the girlfriend refused to pursue the slashed tires allegation. So he was released in January, but this officer made sure that he was put on high supervision probation, which meant he had to report in monthly, which I guess is a more frequent requirement than is standard. So every time he met with this guy from January and February and March and April, he never had this bag with him.
I'm a little confused. You said after he got the tip from the girlfriend, they wanted to search the residence where he lived with the girlfriend,
Yes,
and then she refused.
correct.
Why couldn't they just go ahead and search anyway, based on the tip?
Well, that was actually pursued, I think, at the hearing. My opposing counsel here did pursue that. I think there was an issue if the person that owns the apartment or the house refuses consent for the officers to go in, they don't go in. Now, whether or not they might have
So if the
pushed the issue.
parolee is living with somebody
Yes.
and that person says, no, you can't search, then they can't search?
That's what the parole officer's testimony was, I believe. Maybe they can, but they must not do it. You don't do it if the person who owns the residence doesn't give us consent. So they didn't go in and search the residence. She didn't pursue the charges, so he's released in January, but he's put on this higher level of supervision, which I would say that was the officer's following through to the best he could. You might argue very reasonably, whenever he did not search this guy every time he saw him, January, February, March, April, and you could say that goes to his reasonableness in the sense that the tip was really much based on a bag. If he's got this bag, there's a gun in the bag. The day he was searched was the very first day the officer encountered him with the bag, and that's why he told his partner, he said, I've been told that this guy carries a bag that looks like that with a gun in it. And this was a tip that was 4 or 5 months old.
And the bag he carried was a very distinctive pattern. It's this designer bag that has a very...
Checkered Louis Vuitton.
Correct.
Yeah, it had some identifiable characteristics, I guess, yes.
But that wasn't what was described in the tip, was it? It was just described as a beige
Beige
bag.
bag, yeah.
Does that make a difference?
I think it just depends on the subjective, how verbal somebody is and how descriptive they are. Whatever this officer saw in his mind, he assumed that this was it was close enough in appearance that he assumed this was the one the girlfriend must have been referencing. And he also had a tip from the mother that said that this guy hangs out downtown with a bag with a gun. So he had 2 identifiable tips, people he knew, they weren't anonymous. He acted on it in real time the first time he encountered this man with the bag, which was always the subject matter of the tip. Basically, it's the state's contention that he would have been unreasonable and derelict had he not pursued this. In fact,
You're at your time if you want to
Oh,
reserve 5 minutes.
I shall. Thank
Okay,
you.
thank you.
Police Court, I'm Derek Gustafson. I represent the appellee, Deshaun Jenkins. State's correct. The standard here is reasonable cause. He's articulated his reasonable grounds, but in his statute, in his brief, he cited the statute which says reasonable cause. I don't know that there's a difference between those two, but the language is slightly different. He also did say something I'd like to clear up. Client was not on parole, he was on PRC, which is different. That's a definite sentence, so he's entitled to release at the end of his definite sentence, but he's supervised by parole like a parolee. So,
And it's the same standard that we apply as far as searching, right?
correct, yes.
And
So-
can I ask, though, is your main issue here the staleness of the tip? Or is there an argument that the tip wasn't enough to search at all?
The tip was enough to search initially in December, which they did.
It was or was not?
Was.
Okay,
So in December, when he gets the tip, he searches and he arrests Mr. Jenkins on the 22nd of December.
okay.
So they set him for a sanction hearing. The tipster doesn't appear, and he's released on January 11th.
And when he's arrested, he doesn't have the bag. Is that
Doesn't
correct?
have the bag. They don't search. In the hearing, we questioned the officer about why didn't you search, because this was his registered address. My understanding would be they would have the right to search. So I felt, he said no, so that's what it was in terms of the testimony. I found that unbelievable. I don't know what the trial court did with that. But we
So
think
he was
that's-
arrested and his person was searched. The residence wasn't searched, but you would agree that the tip would have been enough to search the residence?
At that time, yes.
Okay.
And he was also asked, did you go get a search warrant? And they did not. So he's arrested, he's held for 14 days in the JC. So I think it's the combination of the staleness of the evidence as well as with this intervention in terms of criminal activity. He's arrested, he's in
Well,
jail, he's not committing criminal activity at that time.
Was he arrested because of the content of the tip? Or was he arrested because of the allegation that he slashed her tires?
One and the same, because as my understanding in the record, that's all the tip. Hey, he slashed my tires and he carries a gun. So that's what came in at the same time.
Well, I mean, slashing a tires wouldn't be from a gun, that would be from a sharp
From a
object of
knife.
some sort.
And the officer said he's not allowed to carry a weapon, and it's like, okay, what kind of knife is it? We have knives that are used as tools, we have knives that are adopted and used as a weapon, so there can be a different type of knife, but that was not set forth by the parole officer. So,
Okay.
but he's arrested because he's potentially engaging in at least one criminal activity, whether it's slashing the tires or carrying the gun. Either one would be sufficient for the arrest for violation. So they don't find a gun, they don't find anything, and he's released. And so my point is, and the court even mentioned this, he was going to focus on, the trial court was going to focus on the staleness and the intervening cause, being the arrest and the detention in jail where he's not committing criminal acts. And then he's released.
Is there anything in the record that tells when the tip from your client's mother took place?
My belief is it was in December. I don't know that he put an actual date on it, but I believe the question was, did you have any other information at the time you arrested him that he was engaging in criminal acts? And that's when the officer said, well, we also had a tip from the mother. So I think the record's pretty clear that the tip from the girlfriend and the mother came in December, then he's arrested, held for 14 days, and then released.
And the mother's tip was that he carried a gun?
Yes.
Okay.
So.
Now, when he's arrested, you said he didn't have the beige bag that the tip indicated contained the gun, correct?
Correct.
And then he's put on this elevated supervised release where he has to meet with his probation officer monthly. Is that
Correct.
right? And in each of those monthly meetings, he never had the bag.
Never has a bag, he's never searched. So
And the
February,
only time,
March,
the
April.
first time he has a bag is when he meets in May.
First time he has a bag. I don't concede that it's the bag. I
Well,
think the rec-
as I
think the
said, a
record-
bag. First time he has a bag is in May.
Well, there's no testimony about whether he did or did not have a bag in February, March, or April. But, so the record's
But
kind
he
of.
did have one in May.
Had one in May,
And
correct.
that bag he had in May met the description of the bag that was the subject of the tip back in December, right?
I don't believe that's true. So the tip is that it's beige. The exchange on cross is at pages 24 and 25 of the transcript. And the officer admits that it was dark brown in color with light colored emblems, and he says it's checkered.
Does it matter, though, as far as the color of the bag or just the fact that he has a bag? I mean, the tip was he had a bag with a gun in it.
I think it does, given the fact that we've now been 5 months past since the first initial tip. And there's been nothing to say that once he's gotten out of the county jail, hey, he's back to engaging in criminal activity. While a gun isn't consumed by criminal activity, it's disposable, it's not something that necessarily would be in the same place all the same time, very transportable, very movable. So there's nothing to say that 5 months later, he's got a gun in a bag, let alone this particular bag. And so I don't believe that tip qualifies at this point in time for all those things, the intervening cause being locked up and the length of time.
Well, the tip was that he walks around downtown with a beige bag that has a gun in it. Is that right?
I don't believe it was that specific, just simply that he was carrying a gun in a beige bag.
And he walks around downtown with it.
Well,
Isn't that why the probation officer wanted to meet him downtown? Because
I
he
believe
understood
that-
he's,
I believe that they met each and every time downtown.
okay. Well, assuming that the tip was he walks around downtown with this beige bag with a gun, the probation officer met him downtown. Is that right?
They did meet downtown, they met outside the
Consistent?
Elms and Depke building, corner of Main and Central Parkway here.
And that was consistent with the tip.
Again, walking around downtown is not a criminal activity, so I
I'm
don't
not
see
suggesting
that
it's a
as
criminal
consistent.
activity. I'm just suggesting it's consistent with the tip. Is that correct?
Well, he came downtown to meet the parole officer, so I don't know how that's consistent with the tip in terms of walking downtown, because he's coming downtown at the direction of the parole officer.
Okay, and he has this brownish tan beige bag.
He had a dark brown bag with VL symbols on it that were lighter in color,
Okay, and
that was described as checkered.
are you suggesting that's not consistent with the tip?
Yes. I think that's a fair conclusion by the trial court.
Could the parole officer have searched not just this parolee, or not just this person, but anybody who is on his caseload for his own safety? So, for example, if he had gotten a tip about somebody that he was supervising, that they carried a butcher knife with them, and the next, he saw this person and thought maybe he saw the outline of a knife. Could he have searched the person for his own safety?
So to me, you're describing a situation like a Terry stop. that law enforcement has for personal safety. And that has reasonable articulable suspicion grounds in order for that.
Right.
So what you've described as seeing an outline of a knife on a person, yeah, that would be acceptable, but that's
Okay,
not-
how about if the tip was that, this person, carried this knife in their backpack?
Again, potentially, but what's making this not reasonable grounds in this instance is the duration, the length of the tip, and the intervening arrest and stop in criminality.
Okay.
So the intervening arrest and detention seems to be the main thing here, right? I mean, would you, if there was no intervening arrest and detention, because I'm interested in the staleness argument.
Yeah.
Would 5 months still be too
I
stale?
I think so in this context, because even without the arrest, the officer doesn't receive any information that he's continuing to act in criminality. He sees him in February, March, and April and doesn't search.
But there's no bag.
Well,
Isn't that kind of that was what prompted the search, was seeing the bag?
well, that gave the tip more specific, I'm going to say this wrong, specificity, and just he carries a weapon on his person.
Okay.
So I don't know that leads so much credence that allows it to be forever a tip, which allows a continuing right to search each and every time he meets him, say, for example, over a 3-year period of PRC.
Well, perhaps if he had shown up with a bag and he didn't search him a couple times and then eventually did search him, but here's a situation where he sees him without a bag every single time and then finally with a bag.
Well, I think the staleness at 5 months, since he's not searched him, since he's not received any additional information, has no other additional belief that he's engaged in criminal activity, and the tip doesn't match the bag in question. I think those factors alone, without the intervening, would say that there's not reasonable grounds here.
So even without the detention and the arrest in between.
Correct, I don't think there's reasonable grounds here, but with the detention, I think it's clear that we don't have reasonable grounds for the search. So if there's any other questions, I don't have anything else.
Oh, all right, thank you. You have 5 minutes.
Very quickly, I'd like to note that the staleness argument really has to be evaluated in the context of his obligations under his parole, his probation agreement, which extends for the entire length of however long that is. If he's on probation or parole for 2 years, 5 years, he's got to not have a gun for that whole time.
So are you saying it could never be stale during the time that he's supervised?
Essentially, yes. I do not think the staleness concept is relevant in this context. I think that he signed an agreement not to have a weapon. When the girlfriend called and said he slashed my tires, that was the initial urge to violate him for having a knife. And then later, she says, oh, and by the way, he's downtown with a gun in his bag, which matches exactly what his mother said. He's in downtown with a gun in his bag.
I'm going to ask you the same thing that I asked your opposing counsel. Was, in the record, did it show when the mother said that?
No, you get an inference that it was probably around the same time.
In
period,
December.
But it's not articulated specifically.
Okay,
No,
thank you.
There's no date. But I guess the specificity of the tips are striking. They're not from random individuals or unknown people. They're from the mom and the girlfriend. He acted as soon as he saw the bag with the defendant downtown, which matches up. It's completely reasonable, I guess is my point. This is incredibly reasonable what was done, and it was done pursuant to Ohio's probation or parole system, and the operation of that system itself has been held. The operation of it is required for the safety of the community and the rehabilitation of offenders, and it does impinge upon Fourth Amendment rights that the rest of us enjoy. The ordinary citizens, the staleness argument might have more legs. This isn't an ordinary citizen. This is a person who voluntarily signed these rules, acknowledging that he was subject to search under circumstances if the parole officer had reasonable grounds. Reasonable grounds is written all over this record, Your Honor, and that's why the state appealed, basically.
So, should we be looking, in addition to looking at the rules that he signed, should we be looking at the factors like the character of the crime, whether the criminal is nomadic or entrenched, whether the thing to be seized was perishable, or are we to look at those factors?
Yes.
Okay, so, in this case, so for the first factor here, the character of the crime, chance encounter or regenerating crime, how would you weigh that factor? Or how would you ask us to weigh that factor?
Well, I would look at his history. His first offense he was prosecuted for was aggravated robbery with a firearm back in 1994. He has a history with guns that goes back, how many years? So his criminal history certainly weighs in supporting the reasonableness of this action. The type of crimes, it's not possession of drugs that's being pursued here. It's a gun, which, as we discussed, I think that's more in line with, you always carry your wallet, your keys, and your gun. It's not something that's going to be sold or consumed like drugs. So the nature of the contraband weighs in favor of the reasonableness of the action. Again, I just want to come back to the Ohio Supreme Court has basically said in Benton that absent ill will on the part of a probation officer, you've got to trust them in their judgment. Is it appropriate to make a move here and search? And I just think the reasonableness of this is just apparent from the record, Your Honors. That's unless you have any more specific questions, I think it's just a record case in that sense. I think you can read the record and glean from it pretty quickly that the parole officer was reasonable in what he did. Unless you have any more questions, I'll rest on the briefs.
All right. Thank
Thank
you
you.
very much. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Okay. The next case is Nation Star Mortgage versus Cranbrink. Mr. Cranbrink, you have 15 minutes to argue. Would you like to reserve any of that time for rebuttal?
I'm sorry, Your Honor.
You have 15 minutes to argue. Would you like to reserve any of that time for rebuttal?
No, Your Honor.
You don't want to reserve any rebuttal time?
Sure, 5 minutes.
Oh, okay. 'Cause then you get the last word. I'll keep your time. You'll see on the podium, there should be lights up there. Yellow means you have a minute left. Red is you're finished with your initial time. Okay?
Good morning, Justices, and good morning, the appellees. My name is Robert Cranbrink, and I'm here on behalf of myself and my wife, Leslie Cranbrink, the appellants. Thank you for the opportunity to present oral arguments to this court in this case. My wife wishes that she could have been here today, but is still recovering from surgery. In April 2017 and April 2018, Nation Star Mortgage, the appellees charged Leslie and Robert Cranbrink $9,193 each time for forced-placed insurance on property on 9705 Shawnee Run Road, Cincinnati, Ohio 45243. Despite the appellants maintaining their existing insurance policy with the Chubb Group, the Cranbrinks informed Nation Star the charges were erroneous, as Energy Insurance Company had already provided proof coverage. In December 2017, Nation Star claimed that the Cranbrinks account was significantly delinquent. The Cranbrinks disputed this, asserting that the only incorrect insurance charges caused the discrepancy. Nation Star insisted the charges with late fees were valid and offered a loan modification, adding $38,421.99 to the loan balance. Leslie Cranbrink signed the modification in January of 2018 to avoid foreclosure, and payments began in February and March of 2018. However, in April of 2018, Cranbrink's payment attempts were blocked as their calls were rerouted to a Jasmine Tosmas, a Nation Star employee who did not recontact the appellants.
Well, I have a question for you about that. I thought I read, and I can't find it right now in front of me, but I thought I read that the modification, the temporary modification agreement required payment to be sent to a specific PO box.
These
So-
were all done.
Pardon me?
These were all done verbally via phone.
So the
All payments were done.
The first two payments were done over
Correct.
the phone?
Correct.
Okay, thank you.
And the third payment was, as you put the loan information in, was redirected to the Jasmine Thomas.
Okay. Thank you.
Okay. In May of 2018, the Kramericks received a letter stating their loan modification was denied and were instructed to dispute errors in writing. The appellees sent a dispute letter, but Nation Star denied the modifications based on disputed insurance charges. By June of 2018, Nation Star acknowledged receipt of the insurance proof and stated it would correct the errors. A Nation Star employee, Rodney, confirmed corrections were in process and that the foreclosure would not proceed. Despite this, on July 31st, 2018, Nation Star and its attorneys filed foreclosure action contradicting prior assurances. On September 4th, 2018, the appellees filed an answer and counterclaim. The next day, Nation Star moved for dismissal without prejudice. On May 10th, 2019, Nation Star filed for a summary judgment to the counterclaims, which the court granted on February 27th, 2023. The Cranebrinks appealed on March 27th, 2023, but the appeal was dismissed due to a Rule 54B issue. A Nook Pro Tunc entry re-granted summary judgment on August 7th, 2024, leading to another appeal on September 4th, 2024. While this litigation was ongoing, on March 25th, 2024, the Nation Star, the appellee, through new attorneys, filed another foreclosure action against the Cranebrinks. The appellants filed their brief on December 4th, 2024, and Nation Star filed its merit brief on January 31st, and a response brief was filed by the appellants on March 18th. I'd prepared a 15-minute dissertation, the oral arguments, but after carefully thinking about it, it occurred to me the appellants Leslie Cranebrink and Robert Cranebrink, pro se, do not have the knowledge that the court has, are not smarter than this court, and therefore will not pretend to be smarter than the court. We will therefore rely on our brief and response brief for the majority to show that the appellants Leslie Cranebrink and Robert Cranebrink arguments have weight and relevance in this case, and that any pro se argument from the appellants, non-studied, non-lawyers, would be an insult to this court. The appellees will speak to a specific part of this case, which is the summary judgment, in particular aspect, disputed material facts. Under Ohio Rule Civil 56C, summary judgment is only appropriate when there is no issue as to any material facts. The moving party is entitled to judgment as a matter of law. In this case, the record clearly contains conflicting evidence. I have highlighted a few of these dispute facts in response to the breach, such as I have listed 17 of them that are already in my response brief, and I'll just go over a couple. Quote, Mrs. Cranebrink failed to timely provide proof of coverage. Page 5, line 17 of the appellee's brief is demonstratively false, as the appellants provided proof with Exhibit A on defendant's response to plaintiff's motion for summary judgment.
So wait, just so I'm understanding what you all submitted, you agree that Nation Star did send the two notices that were required by federal law to you, right?
No, we do not.
Okay, they submitted proof of that with their summary judgment. Okay. Did you respond to either of those two notices?
We responded monthly every time we made all payments via phone. We responded monthly, addressed this issue with them, sent them a letter accordingly stating that the insurance was intact. So we constant contact with them.
But so your dispute, the notices that they said they sent and they submitted proof that they sent, you seem to be suggesting you did not receive them or something?
No, Your Honor.
What were you responding to?
Every payment was made via phone.
But you said you responded monthly.
I'm talking about the insurance.
Right. So every time that we would make a payment, there would be a different amount that was required by Nation Star. We would say that we already have insurance, that insurance is erroneous and would pay the base amount without the insurance coverage.
You would say that orally?
Said it orally every single month. And
So that's, when you would call in to make a payment, you would learn at that point in time that they were charging you for insurance.
correct.
And then orally, you would tell them you had insurance.
Correct.
But you never sent them proof of insurance
Yes, we did.
until the end, but not after they finally kicked in charging you for the insurance. They sent you 2 notices requesting proof of insurance, and you never sent them proof of insurance, right?
We had Energy Insurance contact them and provide proof,
So-
which is in one of our documents.
So I have a note here that I made that you provided Nation Star the proof of insurance in July 2018. Is that correct? You know what, the date doesn't matter so much.
No, we provided it earlier than that.
You did provide it
Yes.
earlier than that, okay. So at some point, the lender canceled the force-placed insurance. Were you reimbursed for any of those, for paying for the force-placed insurance?
No, Your Honor.
Okay, thank you.
Mr. Cranebrook, if I could change topics for a second, but I want to address this before your time runs out. There's a case cited in your brief, Wright v. Bank of America. Are you familiar with that case?
I've read about it, Your Honor. I mean,
Well, we couldn't find it, is my concern. Do you know where that came from?
it was done in my research.
And can you tell us a little bit more about your research?
General Google searches. I didn't use any AI. I just standard searches.
And your testament to this court is that this Wright v. Bank of America cited at 447 Fed Appendix 979 actually exists? There's a case out there that says what you say it says?
In my research, that's what I found.
Okay, thank you.
So I'm not going to go through all the specifics of where I think there are issues with material facts. But I would say the trial court erred in either ignoring and properly weighing the evidence, which is precisely what summary judgment is designed not to do. The Ohio Supreme Court made clear in Drescher v. Burt, once the movement satisfies its initial burden, the non-moving party must respond with facts, and the appellants did. It is not the role of the trial court to resolve factual disputes or make credible determinations at the summary judgment stage. Construing the evidence in light most favorable to the non-moving party, reasonable minds could come to more than one conclusion in this case. Therefore, summary judgment was premature and should be reversed. The appellants also point out to the court that 5 defendants
Just
in the
let you know
county.
you're at your initial 10 minutes if you want to reserve 5, but you don't have to reserve
I'd like
5.
to just,
Keep going.
thank
Okay.
you. The appellants also point out to the court 5 defendants in the counterclaim have yet to file an answer in the counterclaim from 8 years ago, and that the court has yet to rule on 3 motions concerning the defendants' answers. They are as follows. The defendants in the counterclaim, Lerner Simpson, Rolfus Oliver Earls, Carson Rolfus, Bethany Sutter, all filed a motion for extended time to file a response. The appellates filed an motion in opposition of that extension, and then the appellates filed another motion a year later asking the trial court to rule on the previously mentioned motion and reply. The appellates believe the non-response of the trial court to motion, specifically the response to the counterclaim of the defendants, raises Civil Rule 54B issues. It's restrictive to the flow of evidence. It does not allow for appellants to have full knowledge of all the facts in this case, and therefore, in itself, blocks any additional understanding of material facts that could be used in this litigation. Therefore, the appellants respectfully ask the court to reverse the trial court's ruling and remand for further proceedings, including a trial on the merits. Thank you for your time.
All right. You do have a little over 3 minutes left.
Thank you so
So
much.
I will save that for your rebuttal time.
Good morning, Your Honors.
Morning.
May it please the Court, John Murray for Nation Star, the plaintiff appellee, doing business as Mr. Cooper, which is what you'll hear briefly as I speak. The key issues before this court today are those of waiver and reliance on oral representations that were not properly before the trial court as any admissible evidence here. Regarding the forced place insurance, which is generally the primary issue here and seems to be the root of a lot of the confusion, Mr. Cooper has presented affidavit testimony that they did provide both of the two letters as Exhibits A3 and A4, the April 2017 and May 2017 letters informing the Cranbrinks that they did not have proper proof of insurance, that Mr. Cooper did not have proof of their insurance. As we pointed out in our briefing, the issue is not whether the Cranbrinks did maintain insurance, but whether Mr. Cooper had received proper notice of that insurance and whether Mr. Cooper had a reasonable belief as to whether that insurance was currently in place. 12 CFR 1024-37, both in the comments to C13 and in the text of C28, explicitly state that a loan servicer may require written confirmation of an insurance policy. That is laid out in both the April and May 2017 letters. There's an explicit language that says this information must be provided in writing. In terms of any evidence that has been submitted before the court, there is nothing to show that any written proof of insurance for the 2017 period was ever submitted to Mr. Cooper.
It eventually was.
It eventually was. In June, I believe the insurance provider sent the proof over by fax in late June 2018, and it was received and processed by Mr. Cooper on July 2nd, 2018.
And then they ended the forced insurance.
And then they ended the forced insurance.
Was
And
there any, I thought I read somewhere that there was reimbursement.
yes, so the reimbursement is for the premiums. There are
Correct.
additional fees on top of that, and I think that may be where there was some confusion here. It's not as though the entire balance was zeroed out as a result of this. There's also the fact that the insurance policy had gone for over a year, and I don't want to speak outside of the record because a lot of these arguments were not briefed to the trial court, but my understanding on the reviewing the insurance policies is that the insurance policy had been re-upped by, the forced place insurance had been re-upped by Mr. Cooper in April of 2018 after it was first put in place in April of 2017. And upon receipt of the existing insurance, that was applicable for the 2018 period, that re-upped period. But again, the specifics of the reimbursement is not something that was ever argued, disputed, questioned before the trial court and outside the scope of any review here. But yes, I believe it took about a year and a half or so of the forced place insurance.
Do any of the arguments made by the appellant survive forfeiture? In other words, were any of the elements that are being made, or any of the issues that are being raised now, were they raised with the trial court?
Some were tangentially. One of the biggest issues is that a lot of this is based on alleged oral representations. And while the Cranbrinks did maintain to the trial court that there were these oral conversations and claimed that they did record these conversations, the conversations themselves were never made as part of the record. They were never any actual affidavit testimony for them. There was never any deposition done of any NationStar employee, despite this case going on for, I believe, 4 or 5 years before the trial court. In terms of specific arguments, there were, in terms of the forced place insurance, that the Cranbrinks had maintained that they did have the insurance. The argument that any written requirement is in bad faith, that was for the first time brought on appeal, something that was not before the trial court, and certainly to the extent that it is even for worth consideration by this court, it also goes against the statutory text, which explicitly allows for written proof of insurance.
Have you asked, I mean,
Sure.
I read your brief last week. Have you asked us not to disregard any of the arguments?
Yes, many of the arguments before this court we would deem waived because they were not brought substantively. And a lot of these arguments too are made in a bit of a conclusory fashion in terms of specifically, I do have these listed out. In terms of the forced place insurance, the insistence on written insurance, the Cranbrinks for the first time on appeal claimed that the insistence is in bad faith.
The insistence on written proof
The insistence on written proof.
was bad faith?
As
Okay.
the Cranbrinks allege in their brief.
Okay.
Additionally, in the unjust enrichment matter, which, as we've set forth in our brief, This relationship between the Cranbrinks and Mr. Cooper is governed exclusively by the note and the mortgage. Note and the mortgage both have provisions calling for everything related to force-placed insurance, such that unjust enrichment cannot stand. For the first time before this court, the Cranbrinks have argued that actions outside the scope, that Mr. Cooper committed actions outside the scope of the contract or in violation of public policy. There was no discussion or analysis as to how that actually occurred, but even if there were, again, that's not something that the trial court ever had an opportunity to consider. Regarding the alleged breach of the trial plan payment, for the first time on appeal, the Cranbrinks argue that they substantially complied with the terms of the trial plan, as well as arguing regarding procedural irregularity. The record maintains, and the terms of the trial plan payment, the trial payment plan itself, consistently and exclusively use the word receive or received. The operative term to trigger any obligations under the trial plan are Mr. Cooper's receipt of payment in each of the months that the 3 payments are due.
Were they, I don't remember whether I saw this. Were the first 2 payments sent to the PO box?
That is something that is not before the record, and hearing Mr. Cranbrink today say that the first 2 were made by phone is not something that was ever presented to the trial court. That is not a component of this that was briefed or discussed previously, let alone supported by any evidence. But the record does show that Mr. Cooper did properly receive the first 2 payments in the, I believe, February and March. It was the
We
April
don't know
was
how
not.
the payments were made.
I don't, unfortunately. If that argument had been raised previously, we certainly would have prepared material related to that, but it simply wasn't. And related to the third payment, and for all 3, I mean, regardless as to whether or not Mr. Cooper opted to accept payments by phone for the first 2, the trial payment plan explicitly states that payments must be made to the PO box. That
Yeah, but if there was evidence that they had paid by phone the other 2 times, they'd have a better argument.
maybe there could be an
Yeah.
argument there, but it's
Yeah.
simply not an argument
It's-
that
there's nothing
we
in the
ever got to
record.
discuss. Exactly.
Okay.
Yeah, and I cannot confirm that they even were made by payment in the first place, only that the language of the trial payment plan explicitly only provides for payment via PO box. Mr. Cooper received the first 2, did not receive the third. But further, even considering if there were any obligations to accept some type of payment by phone, if we understood what really happened in these sets of correspondences verbally, even then, the trial payment plan is not itself an enforceable contract. It is largely, I would argue that it is more akin to an offer that has the condition precedent of making these 3 payments. That if these 3 payments are made, then we are obligated to offer you a formal permanent loan modification. But certainly as RESPA states and the mortgage itself states, any change to the terms of the mortgage must be made in writing, executed by both parties. The trial payment plan is not an agreement that is signed and executed by both parties. It is at most an offer, such as to say it could not be breached for any cause of action here. I would also argue on the RESPA claim specifically, that Mr. Cooper presented, again, through affidavit testimony, that they do have a protocol and procedure in place for how to handle qualified written requests under 1024-35 or 36, whether that's a request for information or a notice of error. Certainly as one of the larger loan servicers in the country, they handle quite a few of these. They have a pretty rigorous process involving multiple steps of confirmation, ensuring that they are responding properly. Nothing in their system shows any receipt of the customer complaint letter that the Cranbrinks alleged that they sent. And as the terms under, the language under 1024-35 and 36 both state, the loan servicer's obligation to respond to these, both in terms of acknowledgement and substantive response, are triggered upon receipt of the customer complaint. Any argument otherwise, if we were to adopt some type of mailbox rule, equivalency here is largely going to open an enormous amount of litigation for complaints that were allegedly sent. And despite that, the Cranbrinks have argued that once they sent the letter, they brought up the letter, again, in oral conversations with representatives of Mr. Cooper. Those conversations are not themselves a part of the record in any way, and therefore, as a matter of face, not really any further consideration there. But even to the extent that they were, the Cranbrinks never resent the letter. They never, when they learned that Mr. Cooper had not received in the first place, there was no attempt to get that letter back to them in any physical sense. And as RESPA requires, any complaints must be in writing to trigger any of those obligations, both received and in writing. Mr. Cooper has demonstrated, again, they've met their summary judgment burden to establish that they never received it, that obligation was never triggered. But even in arguendo, if they were to have received that letter, the case law is, I don't know if I would argue entirely clear, but generally consistent at least, that the definition of servicing, such as to trigger obligations under 1024, 35, and 36, that loan servicing and issues, or I'm sorry, that issues related to loan modifications and trial plan payments do not fall within the scope of loan servicing, such as to trigger those responsive obligations.
Also, even if he had received the letter, you're saying he wouldn't have had to respond?
Exactly.
Oh, okay.
Yeah, so it fails for a few reasons here. Certainly, Mr. Cooper likely would have responded in some way, but that response would not have been governed by any of the obligations set forth under 35 or 36.
Counsel, are you familiar with this Wright v. Bank of America case?
I had the same issue as you, Your Honor.
So you weren't able to find it?
No. With the, let's see, I believe I've largely hit most of what I was originally going to address. I did also want to state and address portions of the appellant's reply brief where they list out, as Mr. Krenberg said, the 17 positions that they believe are contradicted by evidence. We would certainly argue that they're not. As a threshold matter, there is no actual explanation as to how the exhibits to which they reference provide any type of genuine issue of material fact. Also, largely, the substance of the documents that they do refer to are themselves not disputed by Mr. Cooper. The majority of the 14 here are relying on the confirmation letter sent by Mr. Cooper to the Krenbrinks on July 2nd, 2018, in which Mr. Cooper acknowledged that it had now received proper written confirmation of insurance. Mr. Cooper does not deny or dispute the terms of that letter at all. They sent it. That is when they did properly receive the insurance. It seems, if anything, the Krenbrinks may have had there may have been some confusion between the various parties as to what the obligations were once Mr. Cooper had received that notice. But again, as established on the record, Mr. Cooper probably complied with all that it should once it received. And the other portion that I wanted to point out specifically was that Mr. Krenbrink stated the loan mod that he signed in February of 2018, that itself was not a loan modification. And it seems that there is a bit of confusion in terms of the damages that could be at issue here, if any. Again, Mr. Cooper would argue that there are not. But the portion that Mr. Krenbrink points to is, I believe, the $36,000 figure or so, which would have been the total amount added to the life term of the loan under the permanent modification, but that permanent modification never came to be. It would only have been offered and triggered upon receipt of the 3 payments. So even if Mr. Krenbrink had presented some argument that adding that amount to the life of the loan balance, even if there was some actionable claim there, that never actually came to be because that loan modification was never executed or even offered and enforced. If there are any other questions?
Thank
For
you.
the appellee. Thank you.
Mr. Krenbrink, you have about 3.5 minutes for rebuttal if you'd like to use it.
Thank you, Your Honor. I would only point out to the court that Mr. Cooper acknowledged in July that there was insurance, force-placed insurance, and that there was more monies within the account at that time, and that there was a balance owed by, we did not get the final numbers, by Mr. Cooper to us.
Let me stop you for just a second. I just want to clarify, when you say balance on the account, you're talking about the escrow account, correct? That was my reading of the documents.
There was escrow monies, there was also monies from overpayments and late charges that were attributed to the insurance aspect. So there were late charges for non-payment of the forced insurance,
Okay.
and those were adjusted. And so during this entire time with the communications with Cooper, they acknowledged on the phone sometime in May that they had made an error. They acknowledged it again in June via writing, or in July via writing, yet in July 31st, they went ahead and filed foreclosure, although they were recalculating what the payments would be and how they were going to do it. So they filed the litigation post-knowledge that the insurance was intact for the entire period of time. Thank you.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your day, and that concludes court for today.